Hi, this is Samantha from the law offices of Samantha Wolfe, and we're located at 20 East 6th Street, Suite 206 in Waynesboro. You can reach us at 717-655-2676. And this video is offering a hypothetical, and it's supposed to be used along with the last presentation I did, where I did about an hour talking about asset protection using irrevocable trust to provide some asset protection for an estate planning client. So again, this is just offering a hypothetical. What we typically do is we have free initial consultations in our office, and what we might ask a client to do is to fill out an estate planning worksheet that provides us asset information about that client, how things are titled. And then what we're able to do using that information is create an asset protection plan specific to that client. And we're able to make specific recommendations about what to transfer to trust, what to do with the beneficiary designation. And so this is an example of what a visual would show. We typically do a written plan that in layman's terms explains the terms of the trust and offers recommendations about what we think they should do with assets. And then we do a visual that shows the different trusts and who's the trustee, who's the trust protector, who's the beneficiary. And so what I wanted to do is I wanted to give you an example. Again, this isn't designed based on a real life situation. It's more based on kind of what I see a lot of clients have, and just offering it as a way to show what would an asset protection plan look for a couple with similar assets or in a similar situation. I welcome any questions that anybody has about this specific hypo, or maybe you just want to talk hypothetically about a client you have and what ways they can offer asset protection. I'm happy to do that. So this is hypothetical number 1, and this goes with the presentation called What's in Your Closet. And I'm also going to do a second video with the second hypothetical, little different circumstances, and show what type of planning we would recommend in that situation. So I'm going to share my screen here. So this is hypothetical number 1. So I'm actually basing this on my parents. They're good sports about allowing me to use them in my examples. So Denny and Denise, my parents, they're both in their early 60s, and they've been married for over 40 years. They have 4 daughters. Like I said, I'm one of 4 girls, and actually the third of 4. So 3 of my sisters, all 3 of my sisters are married. And let's just say for this example, they love 2 of their son-in-laws, but aren't real fond of one of their son-in-laws. Like I said, an unmarried daughter, and then they have 1 granddaughter, Audrey, who has special needs. And their estate consists of the following assets. Now, again, I just wanted to give, this is an example of what I see a lot with husband and wife. So let's say they have a primary residence, and that in this example is worth about $300,000, and let's say that it's owned husband and wife. So tenants by the entirety are jointly with husband and wife. They have a bank account with about $15,000 that's jointly titled. Husband and wife's name is on that. We have an investment account that has about $275,000. That's husband and wife joint. They have a second investment account that's just in wife's name that has about $150,000 in it. Husband has an IRA, a retirement account, about $200,000. And then wife has a retirement of about $100,000, and that's in an IRA as well. So their total estate is about $1,040,000. And let's say they come in, do our free initial consultation, and they disclose this asset base for me so that I know what they have. And again, we always welcome the financial advisor to be present at the initial consultation. And then what the client says, as part of my job, is to uncover what their concerns or what their goals are. So let's say that one of their concerns is that the unknown future spouse of their unmarried daughter, Audrey, who has special needs, they want to make sure that they are protecting her and also allowing, if she's able to qualify for any benefits, they want to make sure that whatever inheritance they leave her won't jeopardize those benefits. They don't want that son-in-law to receive any part of the estate if their daughter should predecease. Or even upon her death, if there's money left over, they don't want that to go to that spouse. And then the last thing they mention is long-term care as they age. Now, I'll be honest, most of the time when clients meet with me, they actually don't mention the last one. I usually bring it up because I feel like it's a topic that we need to discuss. And I need to be able to offer them some examples and some planning techniques that would provide some protection if that's a concern. Now, like I discussed in the last video, in this situation, if we take my mom and dad, let's say Denny goes into a nursing home, what we have to understand is that the primary residence is an exempt asset. Their vehicle of highest value is an exempt asset. And if my dad goes in, his retirement is available, but my mom's IRA of $100,000 would not be available for his care. So you take the house off, you take my mom's retirement off. Then under the Medicaid rules, it would allow my mom to keep about $128,000. And that's just an approximate number. It changes every year, but it's about $128,000. So she'd be able to keep the house and her retirement and about $128,000. The rest of the money could go to pay for my dad's care. But one of the things I want to talk to them about is, do they want to make sure to protect assets so that if one of those goes into a nursing home, the other spouse is not financially compromised? The other thing is that if only one of them needs long-term care, but the other spouse, they need assisted living level care, I want the trust to be able to protect the assets so that they can be used to pay for the assisted living while the spouse that's in the facility care. So those are just some things I'm looking at. So when I'm looking at the asset base, that's what I'm doing. I'm kind of saying, okay, what are all the assets? And I'm saying what are exempt, and we're going to take them out. And then what is available and for long-term care. Now, I want to mention something about the primary residence. I think I've mentioned this before in other videos. Even though the primary residence is an exempt asset, if my dad would pass away while he's in a facility and Medicaid was covering it, what would happen is they would put a Medicaid recovery lien on the house that would kick in when my mom dies. So, if it were a house that my parents had been planning, let's just say to leave to me, that would be jeopardized by a claim. It would be the Department of Human Services claim, a DHS claim against the estate. DHS can make a claim, the Department of Human Services can make a claim if somebody was receiving long-term care, was using Medicaid to pay for that, and anything that passes through the will would be subject to a Medicaid recovery. So the primary residence is an exempt asset. Sometimes, or a lot of times, we actually do want to transfer that into the trust to offer some protection. Now, there's some basic things here that I would recommend. So the first thing is the investment account that wife has, regardless of what they do with it, wife should probably add husband's name to that as a joint owner. And the reason why that's really important is they're in a long-standing marriage, so it wasn't separate property there. Sometimes when we have blended families or a second marriage, we might not add spouse's name to it. But in this instance, I'm going to recommend that. And the reason is because if we add husband's name to the account, then when wife dies, these assets, for example, don't have to be probated to transfer them to the husband. So if my mom would die first, that $150,000 that's in that investment account would go through probate unless there was a transfer on death designation or a pay on death designation or a beneficiary designation. Because she's the sole owner, unless it has a beneficiary designation or a joint owner, it's going to go through her estate. So I would either recommend adding husband's name to the account or having a transfer on death or a pay on death designation on there. The other thing to remember is that because there's retirement involved, when the first spouse dies, even though you may have the surviving spouse as the beneficiary, under Pennsylvania law, you still do have to file an inheritance tax return and disclose the value even if it's not taxable. So I wanted to make sure I mention that. And again, the other thing I wanted to make sure that you're going to see off to the right there when it kind of designates what we're going to do with the asset. We never transfer IRA funds into the trust because that will trigger all the deferred taxation. So we're not going to transfer ownership. But in the example that I gave, if my dad goes into a facility, my mom's retirement is not available for his care. But if she dies and my dad is designated as the primary beneficiary, that retirement that wasn't available while she was living does become available upon her death, my dad's beneficiary. So we may designate these asset protection trusts as the primary beneficiary so that when my mom dies, if she's the first to die, if my dad's in a facility, it does not go to the facility, it would actually go into the trust and be protected. Now, what we do is we actually tier our beneficiary designations. And what that means is that we'll name the trust as the primary beneficiary and the spouse as the contingent beneficiary. And we do that because if the spouse isn't in a facility at the time of death, so if my mom dies and my dad is not in a nursing home receiving Medicaid benefits, he is going to be the trustee of these asset protection trusts. He would be one of the trustees. Both of my parents are going to be the trustee. And so as the trustee, he does have the power to disclaim. And disclaiming means he has the right to say, I do not want it to pay into trust. I want it to pay to the contingent beneficiary. And that would actually pay to him directly. So it allows us to say, we don't know what order someone's going to die or if somebody's going to be in a facility, but what we know is that we can designate the trust. And then if we don't want it to pay into trust, we can disclaim and have it pay outright to the spouse. And we do that for tax planning purposes too. So we want to make sure we're balancing the income tax ramifications as well as the long-term care planning ramifications. So this would be an example, like I said, of an asset base that husband and wife would have. And I do have designated kind of what we're going to do with it, but I wanted to, so you could see this in writing, wanted to show this. And now what I'm going to do is I'm going to flip to the visual. So we would take all of this information and we would do a written plan and a visual. And let me show you what the visual would look like. Just a minute, let me find what I'm looking for here. Here we go. Okay. So this is an example of hypothetical number one. So we have, and I use my last name because this is my parent. So it's the Wolfe Primary Residence Protector Trust. We have the Wolfe Income Only Protector Trust, and then we have the Wolfe Protector Trust. So 3 different trusts, okay? Let's look at the Primary Residence Trust first, okay? And let's go through that. Now, a couple of things I want to say before that. We're not going to transfer all the assets into the trust. Or again, our goal is not to put everything in trust. We're just selecting certain assets or a certain monetary amount that we want to make sure to protect for the other spouse. So we're still going to need a will for any non-trust assets. I wanted to make sure we say that. So clients still do need a will. You can name a guardian for underage children in the will. So you know how I mentioned about Audrey. So what would happen is in the will, you might say it goes to the 4 children, what we call per stirpes. And what that says is that if something would happen to my sister, her 1/4 would go equally to her 2 children, okay? And what we can do is in the will, we can actually say we're going to name a custodian for anyone under the age of 25. In Pennsylvania, you're allowed to go up to 25. You can be between 25. And we're going to say if the beneficiary receives something and they're under the age of 25, this is who's going to be in charge of this fund. So we'd want to make sure to include that. We're going to add husband's name to wife's investment account, like I talked about. Individual assets are still available for the long-term care of the other spouse. So in our example where wife had the investment account, even though husband's name isn't on it, he goes into a facility, that investment account is still available for his care. I wanted to make sure to mention that. So no matter how the asset is titled, unless it's retirement or the primary residence, it will be available for either spouse's care, no matter the titling. Retirement is exempt for the spouses in the community. And like we talked about, the only problem with that is if spouse is the beneficiary, then there would be issues if one spouse died and the spouse that's the beneficiary is in a nursing home. The other thing to remember is that you can include transfer restrictions in these trusts. I'm going to talk about that. So real estate, you could say if one child wants to purchase it in the trust, you could provide for that. You could say, for example, you could say I have the right to purchase the real estate for X amount or for the tax assessed or for the fair market value. So we like to do that in the trust more so than in the estate because that can tie up the estate. And then the designations of a trust as a retirement beneficiary does prevent lump sum distribution. So if my parents, with the new Secure Act that came in at the end of 2019, used to be you could stretch out the retirement over the beneficiary's life expectancy, and you can't do that anymore. There's a 10-year payout. But what that means is that that payout is then available to creditors. So the trust, you can use trust to protect against that as well. So I wanted to make sure to start the conversation by talking about that. Then what I wanted to do was I wanted to go through each trust. So we have the Wolfe Primary Residence Protector Trust, the Wolfe Income Only Protector Trust, and then the Wolfe Protector Trust. The difference between the names. So in our office, we use the names so that kind of as a shorthand for us to know what's being transferred into the trust. Because a lot of times we'll get calls and we'll say, what did you transfer? Who has access to what? And so we identify the titles based on how the trust works. So if you see the word protector in the title, What that means is that we've taken the power of distribution that a trustee normally has, and we've given it to somebody else. Again, if Denny and Denise, if my parents set up a trust, they're the trustees and they have the power to make distributions out of the trust, and it is available for their long-term care. So what we do is we take the power of distribution that the trustee normally has and we give that to the trust protector. And so the trust protector is the only individual who can make distributions out of the trust, okay? So I wanted to make sure to mention that. So if the word protector is in the title, it just means that this trust is an asset protection trust because we've taken the power of distribution from the trustee. If you see the word primary residence in it, that trust is used to own the primary residence. Typically, we don't commingle assets. We want real estate to be in a separate trust. So that's why primary residence is in the title of the one. And then income only is in the title of the middle trust. And the reason why is because there are two ways that these trusts can operate. Either every distribution out of the trust requires that trust protector to make the distribution, or we can actually separate it a little bit. So if my parents, for example, transferred that $150,000 investment account that was in my mom's name into the trust, we could actually say under the trust document that any interest or dividends, any income generated off that account can be distributed out to my parents every year. So in the example, if we transfer the $150,000 in and it generates $2,000 worth of income in the next year, my parents can actually reach in as trustees and pull out the income. Now remember, because they can reach in and pull it out, then it is available for the long-term care, but it's a nice middle ground. So again, they still have access to interest and dividends, but the principal, the original $150,000 they transferred in, they would need the trust protector to okay that distribution. So that's kind of the difference. So sometimes people will say, well, I want to transfer my investment account, but I still want to receive the interest and dividends. And you can do that using these trusts. Okay. But if Denny and Denise have the ability to access the income or any portion of the asset, then that portion is available for long-term care. So if we're going to give Denny and Denise the ability to access the income, then we want them to take it. Okay. They don't take it. So let's say in 2020, they don't take the income that's generated off that account. What that means is that it gets added to the principal. The original $150,000 gets added to that, and there's a new look back period for that income that was not distributed. So I always advise clients and advisors that if we're going to give them the access to the income, we actually want them to take it. Okay. So that's the difference in the different trusts, okay? Why some of them have income only and why some of them do not, and why we have the word protector in there, okay? The other thing to remember is that the trustee is the person who still meets with the advisor, makes all decisions about investment, buying, selling. They're still the legal owner of the asset, okay? The trust protector is only needed if it has to come out of the trust and it's not considered income in an income trust, all right? So let's say the primary residence, and this is mom and dad, they're the grantor, they're the trustees. They can control the asset. Nothing's changing with how they live day to day. Still the legal owner of it. They still get the homestead exclusion. They still get the 21 exclusion. All of that stays the same. They still get a stepped up basis when they die on the value of the real estate. Okay? The successor trustee is just who handles the trust assets when my parents both pass away. So I put my name there in the example. And then the trust protector is just who has the right to make distributions out of the trust. So again, in the example of them selling their house and downsizing and then wanting to pull some of the sale proceeds out, that's where they would use the trust protectors. That would be my sisters and I. So we'd be able to reach in and pull assets out of the trust that they would need. That's the only job the trust protector has, and they are only going to act when something needs pulled out of the trust. Okay. You'll notice here we have income beneficiary during life and then beneficiary during life. You're going to notice that that is the children. That's my sisters and I. We're the beneficiaries during life, and upon death, we're also the beneficiaries. So again, the only way you can get assets out of the trust is if the trust protector makes the distribution. Now remember, Denny and Denise, my parents, can fire the trust protectors and appoint somebody new at any time as long as they're not appointing themselves. They also have the ability to add and remove beneficiaries at any time as long as they're not appointing themselves. Okay. And then upon the second spouse's death, I'm looking at the Wolfe Primary Residence Protector Trust. Upon the second spouse's death, the trustee is going to divide the remaining trust assets into separate trust shares for their descendants post. That's where, if we scroll down here, you're going to see it gets divided there are 4 of us, and each sister gets their own trust. So my sister Amanda has her trust, Krista has her trust, I would have my trust, and my sister Jessie would have her trust. That's what that means. We're taking whatever is left in the trust when the second spouse dies and dividing it 4 ways. Like I said, you can also include something in here talking about how a beneficiary has the right to purchase it if they want, and you can put this purchase specifications in the trust as well. The second asterisk is saying upon Krista's death, any remaining trust assets paid to her children. Audrey's share is going to be held in the special needs trust or supplemental needs trust, and the trustee will be me. That's designed to, we can do a special needs trust that would allow Audrey to receive her inheritance, but if she's able to qualify for any government benefits, to still be able to do that as well. So that's why we're putting her share in a special needs trust. The next asterisk is saying upon the death of any daughter without issue, that would be me, I don't have children, the remaining assets are going to pay equally to the surviving daughter's separate trust shares per stirpies. So if something would happen to me and there are assets still left in my trust, my 1/4 gets divided equally among my 3 sisters and gets paid to their separate trust. So that way, if my parents had it paid to me outright, so if it wasn't held in trust, then that would mean that when I died, it would go according to my will if I had one, or it would go under Pennsylvania rules of intestacy if I didn't have a will. So leaving it in trust to the beneficiaries allows my parents the ability to say, well, if one of them dies, this is how we're going to handle that. Okay. Now, if you look down here, each of us have the ability to serve as our own trustee, and we can distribute income and principal for our health, education, maintenance, and support. Now, that does mean that the assets inside the trust would be available for child support or spousal support if that would be awarded. But it still does protect us against some of our creditors. Now, to get even more creditor protection, I would advise my parents to allow us to name an independent trustee, which is somebody that's not related to us, that doesn't work for us. As soon as we appoint that independent trustee, then the trustee has the ability to distribute assets for whatever they deem advisable, and that would actually give us the most creditor protection. So using it in separate trust shares for each of us, with us serving as our own trustee, gives us some creditor protection, but not all creditor protection. But again, in this trust document, my parents have allowed us to appoint an independent person, and if an independent person is appointed, then we do have creditor protection from everything. Okay, so that gives us some flexibility as we get older, because right now we're in our 30s, so we might not want that long-term care protection, but as we age, we may. Okay, the Wolfe income only protector trust looks a little bit different. You're going to see the difference right here with the income beneficiary. So during life, the grantors, or Denny and Denise, my parents, are the beneficiaries. They can pull out the income. We're also the beneficiaries, but the trust does specify that the trustee can make distributions to any of the income beneficiaries, and they can be unequal. Okay, so again, my parents can pull out the income themselves. They can pull it all out. Okay. The principal, though, would require us to pull it out. Okay. And then upon the second spouse's death, the trustee is going to pay the remaining assets equally to the separate trust shares down here. So the ones that we saw down here. Okay. And then the last trust mirrors this primary residence trust. It's just it's being funded with non-real estate assets. So if, for example, we had life insurance that we wanted to protect the cash value, or if we had an investment account that we didn't want the income off of, you'd put it in that trust. Now, one question I get asked a lot is, tell me, advisors and accountants and CPAs rightfully ask, tell me about how this is taxed. So you have to go through the different tax. So there is federal gift and federal estate tax. Any transfers to these trusts are not considered completed gifts for federal gift or federal estate tax purposes, and that's because my parents in these trusts retain the power to add and remove the beneficiary at any time. So it's not a complete gift. So when mom and dad fund these trusts, no 709 has to be filed showing that it's a gift. Okay, it's not using any of their federal exemption up either because it's not considered a complete gift. The next tax that you move on to would be income tax. So these trusts are all grantor trusts. Even though they're irrevocable, they're grantor trusts. If you look at the instructions on the 1041, there are 2 methods by which you can handle a grantor trust. The first way is that you can report it under the grantor's social security number. The second way is that you can actually get an EIN and report it on a 1040, but it's still taxable to the grantor. So what you have to do is if you're going to get an EIN, you have to fill out that first page with the information and then right across the top that the income's actually being reported under the grantor's social security number and then put the social security number that it's being taxed on. And then it shows up on the 1040, not a K1 because it's not a distribution out of the trust. It's a grantor trust. So for income tax purposes, my parents are still considered the. So typically, most accountants just use the social security number actually as husband as the taxpayer identification number for these trusts, which you can use under the instructions under the 1040. Now, I know some accountants like to have the EIN because for Pennsylvania purposes, on the instructions of the PA 41, it indicates that even a grantor trust, even an irrevocable grantor trust requires an EIN. But even if you get an EIN, it's always taxable to the grantor. It's always going to be taxed to my parents, even if a distribution does go out to one of me or my sisters 9, that's not taxable to us because it's a grantor trust. It's still taxable to them. So even if your accountant recommends getting an EIN and filing a 1041, it's still going to be reported under the grantor's social security number. Pennsylvania inheritance tax is the last type of tax I wanted to make sure to cover. So because mom and dad still retain the power to add and remove beneficiaries, it's included in their estate for Pennsylvania inheritance tax purposes. That's helpful though, because that means they get a stepped up basis. So these trusts are going to be subject to Pennsylvania inheritance tax, and the rate of tax depends on the relationship of the beneficiaries to my parents. So because we're all direct lineal descendants, we would pay 4.5% on the fair market value of the trust assets based on the date of death. 4.5%, but then we do get a stepped up basis. So for real estate, or if we have stocks, that's really important, especially if they're low basis assets, we do get a stepped up basis on 100% of the assets. That means that if we would liquidate it then as part of the administration, there wouldn't be as much capital gains tax on it because the capital gains tax is on the difference between the sale price and the basis. And if we got a stepped up basis, then there's going to be less that we're paying capital gains. That's important because it's a difference between 4.5% or 15 and 20%. Okay, so we do get a stepped up basis, but we do have to pay 4.5% or inheritance tax at whatever rate the beneficiary is on the fair market value when the date or when the second spouse dies. Okay, so stepped up basis, but it's subject to inheritance tax. If my parents would give up the right to change who the beneficiaries are of this trust and survive that by 1 year, then there would not be inheritance tax on the assets inside the trust, but it would not be stepped up basis either on the assets. We have to make sure to remember that. So the important thing to know is they're grantor trusts for income tax purposes. So any distributions out of it aren't going to be taxed to the beneficiary. It's always taxed at the grantor, in this case, my mom and dad's personal tax rate. Okay. So not subject to the trust rates, not K1'd out to the beneficiaries. It's always going to show up on mom and dad's 1040. They're going to pay tax at their personal rate. For inheritance tax purposes, there is a stepped up basis, but it still is going to be subject to Pennsylvania inheritance tax. So I wanted to make sure to run through all of the taxes there. Okay, so I think that gives a nice summary of what we would recommend in this case. So again, if we go back to the assets, we had the primary residence that was worth $300,000. So we would actually put that into the primary residence trust. We're not going to do anything to the retirement other than designate this trust right here as the primary beneficiary, and then the spouse is the contingent, and that's to protect the surviving spouse if they happen to be in the facility because it wasn't available and it would be available all at once. So we would name this trust as the primary and then the spouse as the contingent, and because the spouse is the trustee and has the right to disclaim, we can always get it to the spouse if they would want to do that. We're going to make sure that we transfer any investment accounts that they would want into the trust. So let me flip back to our actual hypothetical here. So here we go. So the house is going into trust. The bank accounts are going to leave in joint names because that every day we don't have to get the trust protectors. So my sisters and I make distribution out of the trust. So again, we're not funding the trust with everything. We're going to put this $275,000 asset into the trust. So we're going to put this investment account into that third trust. It was one on the far left, the Wolfe Protector Trust. That's going to own this $275,000. This trust, the primary residence trust, is going to own the primary residence. And then we're keeping out the bank account and this investment account that was in wife's name, but we're going to add husband's name to it. And then these retirement accounts are staying out of the trust. So what we've been able to do is we've been able, in essence, to protect $575,000 against long-term care costs. Now, as mom and dad age, as my parents age, they can always choose to add some of this investment account if they want to one of the trusts. And if they do that, then it does start a 5-year look-back period specific to when they add that asset. Because like I said, the 5-year look-back period starts when you fund the trust. Okay. But know that they're always going to leave this $300,000 out. So if we're worried about a 5-year look-back period, they do have $300,000 that can be used to pay through the 5-year period. They would need to. So again, we're putting the primary residence in this investment account, which protects $575,000 for them, and the rest they could keep outside of the trust. So that way we're just earmarking or protecting a certain amount for the next generation, but the rest can be used to pay for care. And again, we can always be more aggressive with the funding if we would want to do that. Okay. So I hope this hypothetical was helpful. You're always welcome to reach out to me. Like I said, I'm at 20 East 6th Street in Suite 206 in Waynesboro. And you can reach me via phone at 717-655-2676. And I'm happy to answer any questions about this hypo, as well as any hypotheticals that you might have related to any clients. And we do offer a free initial consultation. Happy to talk to about these type of planning techniques with your client. I do encourage you to either go back and listen to the What's in Your Closet presentation, and I would also encourage you to listen to the hypothetical number 2 that I'm going to be taping as well, just so you have a clear picture of all of the different options. Okay. Thank you so much. I appreciate you taking the time to listen, and hopefully it's helpful.